Russian roulette. I don't know. Maybe that's your gig. Different gigs for different pricks, I guess. So the birth certificate is a certificate of indebtedness. It is a warehouse receipt known as a bill of lading for manifest shipping cargo, showing what's on the cargo, okay? And what I find very interesting is when I express it to people that it also evidences a United States vessel, a United States citizen, and it is a domestic trust. I don't know why people have such a hard time wrapping their head around that. Understanding that it's a bill of lading, a certificate of indebtedness, it's a warehouse receipt as well. All right? Now, the birth estate holds assets, holds value. And the best way to explain this is like when you do, when you get like a grant deed or a joint tenancy deed, and you read it and it says lot, block, parcel ID number, zone improvement project number, address, easement, buildings, fixtures, immovable and movable, right? That's essentially what your birth certificate is. That's what everything attaches to. So the automobile, the house, all that stuff affixes to that vessel. All right? And that's where they take you. If you violated one of their policies, you're going to want to liquidate your assets of the vessel that you think you own, but you don't own. You're really a tenant. All right? So the birth estate is not where the value comes from. It's what holds value. The Social Security juristic person is the one that is the trustee that moves the value to and from the estate, okay? And it also is your intermediary between the Treasury, the IMF, the DTC. So what they're doing is they're charging up that Social Security juristic person under foreign law, statute, code, city ordinances, rules, and regulations. And they're trying to entice you to come out and authorize the transaction, because once that Social Security juristic person trustee is charged up, an automatic transaction happens between the Treasury where they disperse in good faith to whatever organization charged up your Social Security juristic person, the trustee, okay? So they're getting an advance in the court. When they charge up that Social Security juristic person, they're getting an advance. The reason that they issue the summons or the warrant or the capias, because they really don't have warrants, it's very rare that I see a warrant. I've seen 2 in my entire life, and that's because somebody actually caused harm, damage, loss to another one. They were federally indicted, so on and so forth, and it was a true bill. What they're doing on the state level is robbing us fucking blind. I mean, it's grotesque how bad they're robbing us. So they charge up the Social Security juristic person, and because they did that, they get an advance from the Treasury, and they can't cover the capital gains because they're insolvent under Chapter 11. They don't have what it takes, and what they need you to do is come forward and gratuitously gift it to them by authorizing the transaction. And that's why they issue the capias or the summons to drag you into their venue so you'll authorize the transaction. All right? This is what happens. When the DA lodges, pay attention to the word I'm using, lodges with the clerk of the court the complaint security. It's a complaint security. All right? The DA is operating as though he's an agent on behalf of your estate authorized to charge up your estate. Okay? He then lodges it with the clerk of the court. The clerk of the court then lodges it with the judge, and the judge ledgers it onto the clerk of the court's books. Okay? Onto the clerk of the court's ledger. And that's what causes the Treasury to give them an advance, because on the back of that security, that complaint security, are all the miscellaneous fees, charges, transaction. You got your penal sums, and penal bonds that are all attached to it, okay? And that's why they're getting the advance. Now, if you come into the courtroom and you start fucking arguing like Billy Badass, which I've been known to do, I don't do it anymore, you go into what's called dishonor. I want to explain something to you. There's only 2 ways to remain in honor, ladies and gentlemen. 2. That's it. There are no others. And trust me, you always, always, always want to remain in honor. You either accept and pay, or you conditionally accept upon proof of claim. That is the only way you can remain in honor. Period. If you file a motion to dismiss, you have now created controversy. If you file a statement for more definite statement, you have in fact created controversy. And I'm saying this with all the love of my heart because a lot of you guys aren't going to comprehend what I'm saying. I'm sure there's some attorneys on here laughing their ass off going, this guy doesn't know shit from Shinola. The cheese done slid off his cracker. I'm telling you right now. That complaint security is yours. The advance they got from the Treasury that they're holding in an escrow that you're not privy to, that the judge has constructive possession and control of, okay, belong to you. But what they need you to do is gratuitously gift it to them, and then they don't have a tax liability. Okay, if it's a gift under Class 5 gift and estate tax, it doesn't carry quite the surmountable tax liability. And then they can swing the taxes because they've got more than enough from what you gratuitously gave them to pay the capital gains taxes because it's considered a Class 5 gift and estate tax. All right? When you go in there and you create controversy, by their policies and procedures, they are allowed to sell the complaint security to investors. Okay, they already have those investors, and that's what we're going to be going over here soon. I want you to understand the investors are really their non-for-profit organizations, their judges, fraternities, their IOTA accounts, all these other people that are privy. The politicians have their own little non-profit organizations that all invest in this shit. They're all getting rich off our ignorance, ladies and gentlemen. They're all fleecing our estates because we have failed to gain the knowledge. People will say, wow, they tricked us. Yes and no. Yes and no. But here's the thing. If we're going to point the finger and say they tricked us, doesn't matter. Who's still liable? Who carries a primary active degree of fault to make sure we're not getting robbed? When seconds count, calling 911 is what? Worthless. Right? Right? If you're the man of the house, you're the captain of your ship, calling for other people's support, oftentimes when it comes, it's too late. So we got to learn and point the finger at ourselves and understand that we carry the responsibility. We are liable, and we need to ascend to the mind and handle our shit. The status correction comes with being a man or woman competent to handle your affairs over all men, period, point blank and simple. Being able to handle your banking and financial affairs, being financially literate and competent. That right there is your status correction. Now, if you understand what I'm talking about, and you've studied trust law to any degree, this will be a very simple concept for you to grasp. If the complaint security belongs to you because the district attorney was operating as an agent, an unauthorized, unrecognized agent on behalf of the decedent estate, charging up the estate to create the complaint security that caused the Treasury to deposit and dispense the advance in funds, who do all the proceeds belong to? Whose complaint security is that? If you're the grantor beneficiary, isn't it all yours? Even though the agent who alleged to be operating on behalf of your estate, who's unauthorized, unqualified, and furthermore doesn't have a lick of documentation to prove that he can touch your estate, touched it? Does it make that the prosecutor's property, the judge's property, the clerk's property, or is it still your property? See, I don't care about So long as there's no injured, aggrieved party, I don't give a flying fuck what the allegations are. They are of no consequence and fucking irrelevant. Period. I am the grantor beneficiary appearing by special appearance at this point. And when I say special appearance, what I'm talking about is I'm talking about the constructive possession of the decedent estate property known as the debits that were extended from the treasury that belong to me, and that complaint security, which also belongs to me because they're assets of the estate. So when I say special appearance, what I'm talking about is that complaint security is really being put on by special deposit. See, special appearance has two connotations. In the public, when you say special appearance, you're dealing with territorial jurisdiction, in personam jurisdiction, and subject matter jurisdiction. But when we're doing special appearance on the private, we're talking about a special deposit with that security, and we are in constructive possession of it. And now that you know that you're the grantor beneficiary, what's the only thing missing in the equation to make sure the trustees do their motherfucking job? That's right, a simple parole contract and agreement, or a trust indenture. Doesn't the grantor stipulate how the proceeds or property of the estate are going to be used? And doesn't the trustee have to follow that? Yes, they do. Yes, they do. And so walking into a courtroom, I understand that you're the trustee in constructive possession of decedent estate property. Well, who the fuck are you? I'm glad you asked. I'm the grantor beneficiary, and here's my instructions. Right there. There's the trust indenture. There's the simple parole contract and agreement. And let me tell you something, trustee. Who's the trustee? The judge is the trustee. Mm-hmm. See, statutorily, they say they can't be trustees. But what I think's funny is, in equity, they're trustees just by the nature of the transaction. They're holding something of value without compensating you for it, which automatically, by default, Beatty versus Guggenheim makes them trustees. It's recognized through all the courts, from the highest to the lowest. If you're in constructive possession of property you don't own, and you didn't perform a service for or give value and consideration for, it automatically makes you a trustee by default. It's called the fucking you get for the fucking you thought you were going to get, right? Because that's what the judge thinks. They think they're going to fuck you. I can't be a trustee. What? Well, then you're right. You can't. Statutorily speaking, you cannot be a trustee, so I suggest you give over the decedent estate property that you're in constructive possession of, because it belongs to me. It's a misappropriation of funds. Okay? And it belongs to me. What happens if the trustee doesn't do their job? What in trust law automatically, by default, happens if the trustee fails to follow the trust indenture or the simple parole contract and agreement, ladies and gentlemen? What happens when you demand them to give you the proceeds, the full accounting? You want a reconciliation of accounting. You want to render and settle and close the matter and make sure the taxes are paid. What happens if the trustee doesn't do exactly what the fuck you tell him to do when you tell him to do it? What happens? Breach of trust, that's right. Fiduciary breach of trust. All right? And the trustee is now fired. What happens when the trustee becomes fired? Well, if you're the grantor and beneficiary, you just became grantee absolute. And the trust collapses, the escrow closes, and all rents, profits, proceeds, futures, and annuities are immediately distributed to you. And if they won't do it, what are you going to do? What are you going to do? Well, that's real simple. 3949A, suspicious financial activity report right to the IRS. Okay? These people engaging in business in special starred chambers venues, masquerading around as government, are nothing more than a private, for-profit, ad hoc corporation utilizing the UCC to negotiate negotiable instruments. They're attempting to coerce you using concealment, fraud in the inducement, fraud in the factum, to willingly participate in releasing your property to them to your detriment and their benefit. There is no even exchange there, ladies and gentlemen. That is just sheer robbery, theft by taking, unjust enrichment. All right? They're in breach of trust. They're in commercial dishonor. Just mixed war against the Constitution. Violating your 4th Amendment, your 5th Amendment, your 6th Amendment. Violating the 7th Amendment, the 8th Amendment. Subjecting you to cruel and unusual punishment. All right? This is huge. See, I study equity. That's why Supreme Saint down there, I know he's picking up what I'm laying down. See, I study all facets of the law. People are like, why do you study statutes if you're doing exclusive equity? Why wouldn't you? Why don't you want to understand the yin and the yang so you know how the snake dances? Kind of stupid to go in there and play with something venomous and dangerous and not know exactly the mechanics of its body and how it moves, right? Because then what's going to happen? You're going to put your hand in the wrong spot and bam! You've been tagged. You've been hit. All because you didn't do an adequate amount of studying. Study your adversary. Know them well. I know what they're going to say before I even walk in the room. My mentors, it always amazed me how they were like, okay, so this is what you're going to do, and this is what they're going to say. This is what you're going to do after that, and this is what they're going to say. And I shit you not, the first time I ever went into a courtroom after listening to my mentor, I came back out, and he's just sitting there like, well, how'd it go? I'm like, man, everything you told me that son of a bitch was going to say, he absolutely said. He goes, oh, I know. What about it? I was like, well, I just didn't expect it to be verbatim. He goes, Derek, I've been at this a long time, brother. A long time, and you're fresh. So they're going to do the same old rigmarole. He goes, the more learned you get, they stop reading you your rights. They stop doing all kinds of crazy cracker shit because it's just a waste of fucking time. They just want to know if you're going to allow them to fleece you or if you actually have figured it out yet and they got to cut you a check. And he was right. The more learned I became, the less and less I started hearing, well, we got to read you your rights first. They don't even do that shit with me. Okay? So, you always want to remain in honor. If you're going to go the public route, which is fine, it's dangerous. Equity is way more forgiving. Comprehend and understand this, that if you don't make an issue when the issue presents itself, you waive it, ladies and gentlemen. Remember, you're presumed and assumed in maritime admiralty in the public to be an expert in business. They're not going to give you any slack at all. Okay? So, for example, you got plea and abatement. You got demur. Okay? You got bill of particulars, if you will, or more definitive statement. Because they're using statutes that says he did this or she did that, or if a person does this, the person is guilty of that, or the person did this, or did this, or did that, or did this. It's all bullshit. All right? So you need a more definite statement if you're going to be playing around the public. I wouldn't advise it, but I understand certain people in their acquired knowledge are in certain positions, and that's what they're going to have to work with. So you have your common law abatement. You have your bill of particulars. You have your discovery tools, which is demand for production of documents, letter-rogatory, request for admission, deposition, subpoena ducis tecum, and my favorite that's never talked about, negative motherfucking averments. I love negative averments. If I want to just drive an attorney batshit fucking crazy, I slaughter them with negative averments and affidavits. And I just have fun watching them crawl up the wall. Because the judge is like, now, counselor, I'm going to give you an additional 30 days, but you are going to have to answer those. You are going to have to answer. Because the judge realizes that I'm incriminating the shit out of his colleague. And his colleague could go to prison for a while if he doesn't affirmatively defend himself. So I make it such a nightmare for him, they just want to throw the case. Never mind, I'm not answering that. I've just dismissed it. No, that's fine too. Okay, but understand when they dismiss it, they're still running off with your credits. They're still running off with your securities. They're still running off with the dividends, derivatives, and stipends that come off month after month after month because they're monetizing your shit. All right? They are a bank. The transaction that I'm explaining to you is no different than going down to a local financier, a bank, and getting a loan. There's an application. See, the reason that you don't realize that there's an application process is because the DEA took it upon himself to charge up your estate and create what's known as a complaint security. Now, for those of you that don't believe a damn word that I'm talking about right now, okay? I want you to pull up Supplemental Rules for Maritime Admiralty and hit enter. 1966 Supplemental Rules for Maritime Admiralty and hit enter. And then I want you to go to section E. E is in Edward. And there, right there, in their own language and their own words in black and white, it will tell you the complaint is a complaint security. I'm not just making this shit up. I'll show you where you can go and review it. All right. More so than that, let me do you one better. Let me do you one better. Have you guys found it yet? Special Supplemental Rules for Maritime Admiralty, 1966. And you're going to scroll all the way down until you get to section E, and it's going to tell you that the complaint is, in fact, a complaint security. And I think it's important that I point these things out because a lot of people talk, a lot of people run their yammer hammer, and all they're doing is blowing hot air, and they're not actually showing you shit. Sounds good, don't get me wrong, sounds real fucking good. Regurgitated at a high volume, they might buy your bullshit. But if they ask you where's that at, and you don't know where to point to, you're fucked. You're fucked. Okay? That complaint security belongs to you. All right? The judge is the trustee because he's in constructive possession of decedent estate property without authorization. That is unauthorized, unregistered United States securities, which is a felony. That is why they're going to cut you the check. It's a felony. What they are doing is a felony, along other things. RICO, treason, sedition, insurrectionist behavior, breach of trust. You know, okay? I could go on for days and days, but it's futile. I don't want to do that. So now that we're all up to speed and up to date about what the court system's doing, this literature may make a little more sense to you. When you go into court on criminal charges, remember, there is an implied civil contract. There is no such thing as criminal. It's all civil under 27 CFR 7211. And for reasons of TikTok, I cannot go into all the charges that you would obviously be able to correlate in your mind, but it covers everything from larceny, grand theft auto, grape, to all kinds of other things, okay? Anything that's alleged to be criminal is in fact civil, all right? It's civil, not criminal. There's a book out there called Jurisdiction and Practices of the Court of Admiralty by John E. Hall. Remember, I told you to go look up those special supplemental rules of maritime admiralty that were adopted in 1966. And one of the things that grabbed me by the short and curlies was the fact that they used the same thing that I use in equity. Okay, when there's a conflict of variance between the rules of equity and the rules of law, the rules of equity will prevail. Well, they use that same principle, only they applied it to the rules of admiralty maritime. That's the special supplemental rules that were implemented after 1966 of maritime admiralty. It's based on clerk's praxis. The clerk's praxis was a clerk of the court of registrar of the court's arches under the King's Bench. The Court of Arches is a court of probate. Remember when I told you that the state registrar is a chief probate officer? It's the chief probate officer, meaning that they're the chief probate judge. Okay? So the Court of Arches is a court of probate. Where did that birth certificate come from again? Oh, that's right. A probate venue. And John E. Hall is the one that wrote this book. This book was never intended for public viewing. We are going to try to reprint this book so that everyone can have a copy of it to read. If you want to understand how Admiralty works, this is the book you need to read, and the reason being, read the case of Waring versus Clark. It talks about clerk's praxis in there, and they use it in the vice admiralty courts in the colonies during the American Revolution. This book caused the American Revolution. Ladies and gentlemen, the reason that it caused the American Revolution is because people were getting out of being subject to a fiefdom and being underneath what they perceived to be getting out from under the king's oppressive authority, right? Only to find out that the majority of the founding fathers were esquires, and they entered into treaties with the king, and so you were never really free. You were never really free. All right? Wars aren't won with guns, guts, blood, and glory. They're actually won with the swoop of a pen. It's all done by contract, proclamation, treaties. Remember, declarations start wars, proclamations end them, or treaties, contracts. That's what stops it. All right? What they're doing is all about the bonds, and when you go into the courtroom after you are arrested, they use two different sets of bonds. What they do when you are arrested, they fill out a bid bond. The United States District Court uses 273, 274, 275. That's for the federal side of things. But in studying GSA, I discovered that even when you are in the state court, they're still required to fill out the 273, 274, 275 because they have to indemnify the United States for any harm they might incur. So when the 24, 25, and 25A GSA bonds are issued, the SF 24, 25, and 25A, they also have to issue mirror image 273, 274, and 275 to indemnify the United States in case the United States incurs any harm, damage, or loss due to their action. SF means standard form 273, standard form 274, and standard form 275. This is the United States District Court. There is another set of bonds, and they are all put out by GSA, General Services Administration. I hear a lot of people talk about GSA. I don't know too many of them that actually tell you what that acronym stands for. General Services Administration. Okay, so if you're in there in a court talking about, hey, I want to see those GSA bonds, and they go, what are GSA? See, an acronym doesn't actually mean anything. It could mean draft, stuck in ass. We don't know. But if you say General Services Administration, they're going to say, oh, okay, all right. This guy may be knowledgeable. He actually does comprehend what this means, and we, in turn, do comprehend what he's saying. General Services Administration. That's what GSA stands for. I'm just talking off the top of my head here because I have all of this stuff memorized. GSA, General Services Administration, Form SF, Standard Form 24 is the bid bond. Everyone should have a copy of the bid bond. The performance bond, that's your performance, right, is Standard Form 25, and the payment bond is Standard Form 25A. And put out by the General Services Administration, GSA, which is abbreviated GSA. The GSA is under the Comptroller of the Currency. Ladies and gentlemen, the Comptroller of the Currency, when you start learning banking, the Comptroller of the Currency is so important. It's so important. It's more important, believe it or not, than the IRS, the SEC. It's more important than TIGTA. I'm telling you right now, the Comptroller of the Currency, you all need to be focused on the Comptroller of the Currency, okay? Because the Comptroller of the Currency typically creates the rules, regulations, and procedures that are followed, okay, when negotiating the GSA, or General Service Administration forms, known as the SF 24, 25, and 25A, 273, 274, and 275, which is under the GAO, the General Accounting Office, okay? So the Comptroller of the Currency is underneath the General Accounting Office. This is all just banking business, ladies and gentlemen. You don't have a country, all right? is a business. All right? So underneath the General Accounting Office, you have the Comptroller of the Currency. The Comptroller of the Currency typically creates the rules, regulations, policies, and procedures, all right, which aren't law, but he creates the rules, policies, and procedures that fall within the parameter of the law that has been laid out by Congress or the legislator, okay, which is under the GAO, the General Accounting Office. Okay, you have two sets of bonds. SF, Standard Form 24, Standard Form 25s, and Standard Form 25A. So that's the bid bond, performance bond, and payment bond. And the federal level, you have Standard Form 273, 274, 275, and they're in the same order. Bid bond, performance bond, payment bond, okay? If they're issuing the SF 24, 25, and 25A, which you have the ability to issue, and I'm going to explain this real quick, because I want people to understand that the Social Security juristic person, there is a contract between the United States and the IMF, and the Social Security juristic person and account is a direct result of that contract. This is why you have the ability, okay, having power of attorney, being the attorney in fact, to actually issue GSA bonds. You have the ability to do that, because the Social Security juristic person is a United States citizen and an agent of the government. It's a principle of the government. And there's a contract between the IMF and the United States, okay, to help you correlate and connect all the dots. So this makes sense. This is how they're doing the GSA bonds. They're just simply coming in as the agent, and they're doing it for you because you don't know any better. All right, and their intent behind doing it is to steal from you. It's to rob you. To rob you of your inheritance, to rob you of your estate, which really, they could plunder your estate for 10,000 years and never make a dent in it, because your ability to draw into existence whatever you want is infinite. It really is. It really is. How do you think we got to 36 quintillion due and owing to the people? It's not 36 trillion. It's 36 quintillion. All right? They could never put a dent in it, but it's about sound doctrines and principles. You're going to sit there and let them rob you? You're going to let them hold you as surety and put you in a cage while they reap the rewards and benefit of fleecing your estate to their benefit and your detriment, while they allege that they're defending and protecting your unalienable rights? I mean, the absurdity in all of that is crazy. Okay. What are they doing with these bonds? What's going on in the courtroom is that they are suing you for a debt collection. Now, in all actuality, they're not suing you for a debt collection. What they're trying to do is get you to be the surety for the advance that they got. They want you to cover it. It's called a covered transaction account. They want you to come in and authorize the transaction so they can whisk it away as a class 5 gift and estate. If you're real sweet and nice about it, you'll never see a day in jail. You'll never see a day of probation or UAs or anything else. They just want that transaction when it all boils down. However, if there's a shit ton of people in the peanut gallery, they may have to give the semblance and the illusion that in this country we have laws and you violated the law, and therefore we're going to give you 7 days time served. Right? 7 days time served. What they're doing is, in Maritime Admiralty, what the judge is actually doing, and he's just a ministerial administrator, he's holding your property in abeyance and pretending that he doesn't know who the fucking rightful owner is. They're waiting for you to make claim to that complaint security that's on special deposit because you're the grantor fucking beneficiary. Now, you're not going to say, as grantor beneficiary, it's on special deposit. As the grantor, I'm telling you, that's on special deposit. Well, who's the beneficiary? Don't worry about that. The beneficiary is well known. Beneficiary is well known. Okay? I like to tell them the grantor beneficiary, but when giving the order, understand that the beneficiary doesn't have the capability of giving any orders except for one, and that is a full accounting. So you see how beneficial it is to be the grantor and beneficiary? Let's say they deny the grantor. All right, now we're going to rock'em sock'em robots. Well, I'm coming forward now as the beneficiary. In the capacity of the beneficiary, now I want a full accounting. The trustee can never deny the beneficiary the full accounting. Why? Because that's the only way the beneficiary can hold the trustee accountable for dereliction of duty, misappropriation of funds, unjust enrichment. So there's one power the beneficiary absolutely has equivocally, and that is to demand a full accounting and to see the ledger of all the assets the trustees in constructive possession of that belong to the estate. The beneficiary always has that right of action to demand and compel the trustee to do a full accounting. Now, at that point, they're still telling you to bug off. The trust just collapsed. The trustee is fired for breach of trust, dereliction of duty. It happens instantaneously, and you now become the grantee absolute. Grantee absolute is the absolute owner, the true owner, holding root title. So what the judge is doing is holding that complaint security and the advancement he got from the Treasury in abeyance, pretending like he doesn't know who it belongs to. That's the only issue in the court. I don't care if there's 50 revised statutes you're alleged and purported to have violated. It doesn't fucking matter. You'll have to have faith the size of a mustard seed if you ever try that, by the way. I went after it right away. Didn't really have the knowledge to back it up. There's videos of me going in there and drilling these people for weeks on end about where's my rights, titles, and interest, where's my over-the-counter security, you know. I knew enough to be dangerous. I didn't know enough to enforce it at that moment in time. Now when I walk into a courtroom, a judge will lower his head and bow his shoulder and go, what do you want? So long as I'm not going to be an asshole and try and bite the hand that feeds him, he's cool. But if I'm going to be a dickhead and want sanctions against everybody and fucking, I want to put a ticket on that guy's jacket, and then he gets a little frumpy about that shit. So, what's going on in the courtroom is that they are suing you for a debt collection. It's not that they're actually suing you for a debt collection. They are attempting to get you to fill the role as surety for the advance they got while abandoning your property they're holding in abeyance that rightfully belongs to you. That's what they're doing. What it is an action of assumpsit. The word presume comes from the word assumpsit, which means I agree or I presume to do. An act of assumpsit, which means I agree to a collection of a debt. If you look at these bonds, every one of these bonds, the bid bond, performance bond, and payment bond, all have a penal sum attached to them from the penal code. So they create the statutes, code, city ordinances, rules, and regulations that are attached to a penal code. The penal code has penal sums and penal bonds attached. This is known as trade secrets, and it's also protected under the Banker Secrecy Act. I have looked and looked and looked, and trust me, my resources are great because having the people that I have around me, my resources are really good. To this day, I have yet to find a book that identifies how much each penal sum and each penal value actually is. I have never located one. I have tried and tried and tried, and to this day, to no avail, I have never found one. Okay? But we know that it exists. So those penal sums and penal bonds have value, and there's a book out there somewhere that has the values for everything. And I know what people are going to say. Well, you know, if you look at the criminal statute, it tells you that it could come up to a $10,000 fine and yip. Maybe that is the penal sum. Maybe that is the penal bond, and it's right there hidden in plain sight. And then what they're doing is they take the $10,000 and they're using fractional reserve lending, so that they take 10,000 and they make it, what is that, 100,000? Maybe that is what they're doing, okay? But I've been looking for this penal sum and penal bond book for a long time, and perhaps thinking about it logistically now, maybe it is in plain sight. Maybe it really is right there, attached to it. The reason for the penal sum is if you don't pay the debt, you go into default judgment. Now, I'm going to explain this to you just like a bank transaction when you're purportedly receiving a loan, okay? They have to have a cash collateral deposit, which is their liability, matching your complaint security, which is your asset that got the funds to be dispersed in an advancement from the Treasury. This is nothing more than a banking transaction, guys. They're trying to get you to pay when all you need to do is look at them and say, use the cash collateral deposit to zero balance the alleged allegations or charges due and owing and remit the rest back to me and call it a day. We're done. He who provides the ends provides the means. If I want you to build me a house and you show up and there's no lumber on the ground, are you building me a house today? I guess not. Who carries the liability to pay everybody? I do, because I had a duty to make sure you had the lumber there. You agreed to build me a house. I had to make sure the materials were there, right? So, they're telling you that this is an attempt to collect a debt. They're obviously in constructive possession of the cash collateral account, deposit account that has the funds in it that settle the account. That's why you're expected to bring a bond when you bring claim. You're expected to provide the remedy. That is what's going on in the courtroom. That is why all these guys are sitting in prison wondering what's going on. If you go in there and argue jurisdiction, and you don't remain in honor and fall into dishonor, your ass will surely go to jail. You create controversy, which gives them the ability to sell the security to an underwriter who buys it at a discounted rate and then sells it to tranchers, okay, as an investment. All right? If you go in and argue jurisdiction or refuse to answer questions that the judge or the court addresses to you, they will find you in contempt of court and they will put you in jail. And if you read Clerk's Praxis, that's all they talk about is contempt, contempt, contempt. What they used to do back in Edward I, if you owed a debt, they would send the sheriff out with a warrant to arrest you. This is all civil, ladies and gentlemen. This is not criminal. It's just smoke. It's smoke and mirrors. It's 180 degrees upside down and backwards. It's a smoke screen to cover up what they are doing with mercantile civil law, or the law of mercantile, and what they used to do when they arrested people with a warrant and brought the person into the court and made them sign a bond to release until the civil suit commenced. It actually says civil suit in the Clerk's Praxis. Because why? They're doing everything under maritime admiralty law, law of mercantile. It's all about replevin, garnishment, levy, warrant, okay? Replevin's for you. In a maritime admiralty situation, if they're holding on to your constructive possession property and you don't understand trust law, then your right of action is going to be replevin. You're going to reclaim all that property. You have an interest in all of that. Okay? And the Clerk's Praxis, by the way, is a very good read. Little technical, I guess, but a very good read. One of the technical aspects of it is the fact that it's so old. If you don't have a modern day version of it, the F's are actually S's. That fucked with me for a little bit. There's some transcripts made of some of my thoughts, and I'm going to write it on the board so everyone knows how to spell. This is how you spell Clerk's Praxis. It's CLERK'(S), Praxis, PRAXIS, Clerk's Praxis. And you can find that free online, ladies and gentlemen. You can find it free online. Latin for practice is, if you look up praxis, if you look up praxis, if you look up Praxis. Praxis. You also have, your writ of mandamus. You have writ of quo warranto that come in very handy. But again, I don't want to confuse the shit out of people because I'm dancing between a multitude of jurisdictions here. And for simplicity's sake, we're just going to keep rolling on. It talks about the collection of the debt. What they do is arrest you, then they hold you. Well, ladies and gentlemen, that's a violation of the 4th, 5th, and 6th Amendment right there in and of itself. They're not supposed to arrest you and incarcerate you until you've been found guilty. Guilty. You're innocent until proven guilty. And there's extingent circumstances where they are required to warehouse you, but that's if it was a heinous, capital, or infamous crime. Do you guys know that when they arrest you, they're not even technically supposed to put handcuffs on you? They're only doing that because of policy. They're not even supposed to put handcuffs on you. You guys know that? How many of you guys knew that? Put one in the chat if you understood that. They're not even supposed to put handcuffs on you. But by their policy, they do it. There's only certain circumstances they're even supposed to put handcuffs on you. That's cruel and unusual punishment under the 8th Amendment. Then they berate you around town and amongst the public, making you look like some criminal vagrant, right? Some vagabond that's out causing problems, and everybody and the dog now thinks that you've done something wrong. They're parading you around, damaging your reputation. All right? Then they hold you. Basically, they hold you until the suit has been completed and when they get default judgment on you because of fail to pay the debt. All right? And again, I've already articulated, it isn't a debt, ladies and gentlemen. It's not a debt. There is a debt, but it's not that you owe it. They owe you the asset they're in constructive possession of. They have the collateral deposit account. They have the distribution from the Treasury in the form of debits that belong to you that they got in advance for your complaint security. Isn't that crazy? To learn the truth about why you're being warehoused is they stole your property and they're out to make you the bad guy? Isn't that fucking insane? That's Maritime Admiralty, ladies and gentlemen. There's a mutiny on the ship. The judge is round and around Dizon Tort. All right, Executor Dizon Tort. There's a mutiny on. But I'm telling you, when you learn this, you have all the power in the world to change it, and there is nothing they can do to stop it. Now, I don't advise that you would go into court doing this, because every man is responsible to give notice of his arrival. So we're going to go ahead and put him on notice in advance. That's why you have 30 days before the first hearing, before the arraignment. 30 days. All right? Why they arrest you and then wait 72 hours or longer to get you before the magistrate is so they can strip you of your ability to utilize due process of law and put them on notice of what's actually going on. They need you to enter into that contract. They need you to sign release forms. Release. They're releasing you again. They're releasing your property again. You're granting them and capitulating by participation to the jurisdiction and to bequeathing them the assets of the estate. And that's why they arrest you. 99.9% of the time, they have no grounds for arrest. Let me clarify. There are only 2 reasons somebody can be arrested without a warrant. 2. They're the only 2 that exist. It's been that way since the beginning of the United States of America. There are only 2 reasons that you could be arrested. Disturbing the peace and committing a felony in the presence of an officer or another man or woman who takes you under citizen's arrest because of the overt illicit act that you're engaged in. Those are the only 2 reasons you can be arrested without a warrant. A traffic violation does not constitute arrest. Ladies and gentlemen. Other than that, they got to have a warrant. And when they say they have a warrant, I mean, they got to have it in their physical, constructive possession, along with the affidavit from the judge affirming probable cause exists, and an affidavit and a statement of fact from the injured aggrieved party stating you've done them harm, damage, loss, and wrong with the bond. And they're supposed to give that to you so you can place it into escrow because that is actual money. The warrant, the statement of fact, the affidavits, and the bond all together are a security obligation of the United States and are money. Money. Not going to explain that any further, but I will tell you this. If you read the 73rd Congress, First Session, Volume 77, Part 1, it will become very, 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 very clear to you that contracts are money. That notes, drafts, bills of exchange, bankers' acceptance, trade acceptances are money. Securities and bonds are money. There are only 4 elements in the economy. 4. Bonds, securities, excise taxes, and insurance. Contracts are money. All right? If they don't have a warrant before you that has to be signed with a wedding signature by the judge, has to have the embossed seal by the clerk of the court. Every clerk of the court actually has an embossed seal. Okay? I learned about this when I learned about exemplified records. Man, I had an attorney so pissed off. She was throwing her notebook. She was throwing a tantrum. She looked like a 6-year-old child crying for a sucker. And I couldn't believe it. I looked at the judge and of course, all the cops are looking at me and looking back at the judge like, do you want us to bulldog this guy or what? And he's like, no, court's been adjourned. And she was pissed. And I'm asking for the exemplified record. And she goes, you son of a bitch, you know where it's at. You know, how dare you even ask me that in here? And I looked at him and I go, is this the kind of conduct that's exemplary of a bar attorney? And he just kind of looked at me and shrugged his shoulders, but he was sitting there watching the show along with the cops, you know. And she goes, you need to leave this courtroom right now. And I said, no, am I free to go? She goes, yeah, you're free to go. I said, then I'm free to stay. No, you're not. You're out of here. And I looked back at the judge and I said, I think you full on well know that I own this building. This building is mine. If you ain't got another proceeding in here, I'll stand here the rest of the damn day. Ain't nobody making me leave. And the deputies, I had 4 witnesses with me. The deputies turn around and look at the judge like, you want us to take him out of here? He's being awfully cocky, you know. You can just tell, like, you really going to let him tell you he owns this building? He don't have to go nowhere? And the judge goes, yeah, he can stay here as long as he wants. Court's adjourned. He goes, I'm just merely sitting here watching this. I find it kind of intriguing. The exemplified record is where the sovereign, quote unquote, signs the record after it's got the embossed seal. It typically happens after sentencing, okay? And that too is valuable and belongs to your estate. So anyway, get back on track here. The warrant has to be signed by the judge on the signature line. Underneath the signature line, there are rules and procedures. Has to have their full name, first, middle, and last. Some people don't have middle names, by the way. So there is nothing, it's just first and last. Okay? And it's supposed to be printed underneath the signature line. It's supposed to say the venue that they are in. Ladies and gentlemen, I've only seen one document that was ever signed correctly. One in 15 years. Okay? Where it actually met all the protocols, which I was just blown the fuck away by. It has to have their capacity and what jurisdiction they're operating in. So let's say they're the district court judge for the 8th Circuit Court, Hall County, Nebraska. Okay? And that's what it'll say underneath their signature line. It doesn't matter what their squiggle looks like, but all the information underneath that signature line has to be there or the document fails. Okay? The clerk has to put their stamp or seal, and if it's a real official document, it's going to be embossed, which will be the embossed seal versus the little rubber stamp they use. And then it has to be signed off by the clerk of the court. Okay? And that's a true warrant that has the affidavit and statement of fact of the aggrieved party. It has the affidavit of probable cause when they did the probable cause hearing before the court and submitted the evidence before the court. And then it has the warrant on top of all of that and the bond. All four of those pieces of paper need to be together when they hand them to you. Facts. If they accost you against your will after demanding that and they don't produce that for you and give that to you and they say all they got is copies, okay? It's kidnapping, aggravated assault and battery, it's false imprisonment, and they become 100% liable because they have a duty to know the law and the procedures and policies, and upon their training, they're supposed to do a sua sponte investigation called the sheriff's inquiry to verify that all the procedures, policies, and law were followed. If they weren't followed, that warrant doesn't cover the officers and shield them from unlimited commercial, civil, personal, and professional liability. You wouldn't believe how many cops get sold down the river day in and day out because they run into somebody like me that knows what the fuck they're doing. And the judge is like, well, I didn't even sign that. I didn't even know that was issued. Because what they're doing now is rubber stamps or digital signatures and stuff. And so now the judge has plausible deniability. He said he didn't sign that. I don't know what happened. You guys are going to have to conduct an investigation. You know how hard it is to conduct an investigation and find out and get to the bottom of who did what, when, where, and how. It could take you years. And they know that, and they're using it to their benefit. But understand, when you catch them with their hand in the cookie jar, the first thing the judge and the clerk will do is sell the sheriff and the police officers down the river. They're just low rent subterfuge. That's all they are. All right? Anyone who has been in jail or prison that knows me knows that I am not wrong. Attorneys are there to cover up the smoke screen. What attorneys do, because no one knows what's going on, they led you into dishonor or default judgment. He's very correct on this assessment here. That's exactly what they're getting you to do. They're getting you to either quibble and create controversy, which is dishonor, or not respond because you didn't respond within the 30 days to settle and close the matter, render the account, come in there and claim your property, okay? And they're going to hold you as surety for it because they got the advancement. Somebody's got to foot the bill, all right? And then the court puts... Man, these little people always trying to pop up here and make money. I ain't trying to make money with you, dude. Yeah, I know you see 200 and some people. We don't fleece people that hang out with me. We're not doing that stupid competitive shit. And then the court puts you in prison. Then they sell your default judgment. Who do they sell it to? Believe it or not, the U.S. District Court. The U.S. District Court, ladies and gentlemen, every clerk of the court in every county, don't give a fuck where it's at, has an account, has a cage code and an account directly linked to the U.S. District Court, and the U.S. District Court buys all of these lower court default judgments and judgments, okay? So they can bundle them up like a bunch of chocolate-covered turds and sell them as either government securities or mortgage-backed securities or asset-backed securities because your ass be sitting in jail, so now it's asset-backed, all right? U.S. District Court buys all of these state court judgments. Get on a search engine and type in U.S. courts. I spent a whole 8 hours getting in there. After you get to the U.S. courts, go to the 11th Circuit Court of the United States, Circuit 1 through Circuit 11. Click on Circuit 7. That will take you into the various courts, bankruptcy, district court, etc. Click onto the North Illinois District Court. That will take you to the clerk's office. There's a box there. Then scroll down and you'll see administrative offices where you'll see financial department. It will talk about the Criminal Justice Act and optional bids. Okay, the bids for the bonds, ladies and gentlemen. And this is all spelled out, and they're not trying to hide it. I don't know why no one has found this out before. Go down to list of sureties. Now, why do you suppose they have a list of sureties? Why do you suppose they have a list of sureties in the federal district court? When you get into the list of sureties, it will have FMS period treasury.gov. It's a website, FMS period treasury.gov. This is the Department of Treasury. Okay, when you get into the Department of Treasury, you see on the left-hand side of the screen, you'll see admitted reinsurer. And underneath that will be a list of sureties. Then under that, the words forms, F-O-R-M-S. From there, you'll see about 300 reinsurance companies. They're all insurance companies. I downloaded the whole thing. I have a complete list of them. I also have a list of all the surety companies. There are two sets of companies, a list of surety and reinsurance companies. Under 750 of the Department of Treasury, they have to be certified so they can buy up these bonds. These are the people that are buying these bonds when you went into default judgment, and they can't buy these bonds unless they are certified by the Secretary of Treasury. Next, click onto the word forms, and it will take you to the Miller Act, reinsurance, and will list 3 different kinds of bonds. They don't use a bid bond in the district court. That's why I gave you Form SF-24. All of these forms come out of the GSA, the General Services Administration. Form SF-24, 25, and 25A, and 273, 274, and 275. The 273, 274, 275 bonds forms. The 273 is the reinsurance with the United States. The 274 is the Miller Act reinsurance performance bond. The 275 is your payment bond, your Miller Act reinsurance payment bond. What are they doing with these bonds? They have regulations governing these bonds. There's 2,000 regulations governing these bonds. We are going to make these available. They have over 2,000 regulations. Sorry, I had to skip past this because he's promoting something. If you go into these regulations, what they are telling you is they are buying up commercial items. Ladies and gentlemen, I told you they're a private, ad hoc, for-profit corporation operating as a special Star Chambers venue, masquerading around as a legitimate judiciary and government, utilizing the UCC to negotiate negotiable instruments under maritime admiralty law. Say that 3 times fast. All right? I'm just giving that to you off the top of my head. I've been around this game for so long. It's so simple to see what they're doing. It's tough for a lot of people to wrap their head around. It's very hard to articulate it in the fashion that I just articulated it. If you can master that and articulate it and stand on it, they'll know damn good and well you know what you're doing. Okay? You're a private, ad hoc, for-profit corporation masquerading around as a legitimate judiciary, operating as a special Star Chambers venue that has a DUNS number, has a SAM number. They get federal block grant funding, and they're not government, meaning they don't have a 990, ladies and gentlemen. They're a private, for-profit business. Now, people say, well, I've gotten their 990 before, Derek. I've gotten there. Yeah, you have. Yes, you have. I know you have, because you know what they do? They use the exact same name and create a 501c3 so they can give you the 990 for that one. They use the exact same cotton picker name, identical in every way, but because it's a 501c3, they don't have to change anything, because that's a 501c3, and this other one is a private for-profit business venture. It's an LLC or an S Corp or a Simple Corp, Complex Corp. All right? So when you're getting the 990, understand you're getting bamboozled and hoodwinked. They're handing you that 990 so you'll say, oh, see, they are tax exempt, so they're government. They're a legitimate judiciary. No. That's their pass-through account, ladies and gentlemen. That's their pass-through account for their K-1 disbursements. But what would I know? Don't take my word for it. Read a book. There's no substitution for reading. Read a book. Give me just a brief moment here. I got to wet my whistle. We're going to keep pushing on with the new information that I got from Carl Killicott. I can prove now that the private ad hoc for-profit corporation operating in a special stars chambers venue, masquerading around as a legitimate judiciary, negotiating negotiable instruments utilizing the UCC, I can prove now that they're a foreign banking entity that can extend loans. They're in the business of extending loans, or making it appear like they're extending loans. Because how could you have a debt if first the credit wasn't presented? See, you can have credit without debt, but you cannot have debt without credit. So where did the source of credit come from? Who's the original source value issuer of all issue, creating the credit, manifesting the credit into existence? That's right, me. So if you're saying there's a debt due and owing, how are you going to charge the king a tax on his own money? You can't take my money, make money off of my money, and then charge me the tax on my money. That's insanity. That's insanity. But that's exactly what they're getting away with. That's exactly what they're doing. That's all child support is, ladies and gentlemen. They got an advance from the Treasury. They got an advance. And they're saying that you need to pay back the loan. When did they give you the proceeds? I think it's probably time to collapse that cash collateral deposit account they must have, according to the comptroller of the currency and the Federal Reserve Board of Governors, who states that they have to have a cash collateral deposit account that matches the asset on the books. And that cash collateral deposit account, guess what that's for? Set off. So you don't want to discharge. Discharging, then the offspring, the sins of the father, the offspring will surely pay for by discharging. You want to set it off. Set it off. Everybody likes the ideology of discharge. I don't. Discharge, and we read it in a good book. The offspring shall pay for the sins of the father. That's from discharging, ladies and gentlemen. No accountability. Let's be accountable about it and set it off. You have regulations governing these bonds. 2000, yep, we went through that. If you go into these regulations, they are telling you is they are buying up commercial items. They use the word commercial items. And in 2.01 of these regulations are divided up into 50 parts. There's 1,126 pages in Volume 1 and 823 pages in Volume 2, and they're all on the disc. And what they tell in there is 2.101 defines commercial items as non-personal property. See, they did an unlawful conversion and took your decedent estate property and made it non-personal because you didn't claim it. And so because it's abandoned, they can call it whatever the fuck they want. You might bring me over a duck and I might call that duck a cat. Can you say anything about it? No, you abandoned it. It was a duck in your possession and it's a cat now. All right? What is non-personal property? Any property that is not real estate. Okay? It means immovable real estate is not movable. So it means immovable. Real estate is not movable. Go into your Uniform Commercial Code and look up the word movable and immovables. If you go into, and I'll read it to you, you won't think I'm making this stuff up. Commercial items are commercial paper. I recommend everybody, this is the 8th edition of Black's Law Dictionary. I doubt if anyone in the room has gotten one. This thing is really good. Basically, what it says is commercial paper, negotiable instruments, anything you put your signature on is a negotiable instrument under the Uniform Commercial Code, which is the Lex Mercatorium. It's mercantile civil law, and the reason they use lex mercatorium in the courtroom is because every one of you are merchants at law, and merchants at law is anyone who hold themselves out to be an expert because you use commercial paper. So these people keep trying to pop up. They see all these people in here and they think they're going to make money or something. I'll never allow that to happen. Go away. Shoo, you vagrants. Because you use commercial paper on a day-to-day basis and day-to-day schedule. You are considered to be an expert, and this is why they are not telling you what is going on in the courtroom, because you are presumed to know this because you hold yourself out to be an expert because you use commercial paper all the time, and you've been using it your entire life. Every time you put your signature on a piece of paper, you are creating a negotiable instrument. Some are non-negotiable and some are negotiable. Every time you endorse something, you're acting as an accommodation party. The accommodation party is the one who owes the debt. Or an accommodation maker under UCC 3-419. An accommodation party is anyone who loans their signature to another party. Read UCC 3-419. It tells you what an accommodation maker is and what an accommodation party is. When you loan your signature to them, they can rewrite your signature on any document they want, and that's what they are doing. This is what is going on and what the federal courts are doing. They are buying up these state court default judgments, and these are called criminal cases, but are actually civil cases, and call them criminal to cover up what they are doing. If you read Clerk's Praxis, you find that what they call criminal is actually all civil. They just call it criminal to cover up what they are doing. If you don't pay the debt, you go to prison. Bottom line. I know, I've been there. I told them I wanted the QSIP number. QSIP, I hear a lot of people throw this one out. QSIP, Committee on Uniform Identification Process. Committee on Uniform Identification Process. That's what QSIP stands for. Had a guy the other day asking me how he gets a QSIP, and I said, I'll tell you how to do it if you can just tell me what QSIP stands for, and he had no idea what QSIP meant or stood for. I said, you at least know it's an acronym, right? Oh, yeah. Okay, great. Can you tell me what it stands for? Nope. I said, well, then I'm not going to tell you how to go get one. And it's so simple. I mean, you got a $2,000 smartphone in your fucking hand. All you got to do is type it in, and it'll literally tell you what to do. People amaze me. People fucking amaze me. I told them I wanted the QSIP, Committee on Uniform Identification Process. QSIP is in the DTC building on 55 Water Street. DTC is the Depository Trust Corporation. When you guys start using all these acronyms, you really need to nail it down what they are and commit them to memory, because if somebody learned it, asks you, and you don't know, guess what? They're not going to give you the fucking time of day. DTC stands for Depository Trust Corporation. It's also called the GFCC. The DTCC, that's dog, Torino, cat, Depository Trust Clearing Corporation. So you got the DTCC and the DTC. The Depository Trust Clearing Corporation is also identified as the MSCC. MSCC, Mutual Securities Clearing Corporation. Okay? And excuse me, the Depository Trust Company Corporation, the MSCC, Mutual Securities Clearing Corporation, also identified as the N as in Nancy, S as in Sam, C as in cat, C as in cat, NSCC, National Security Clearing Corporation. See, a lot of people talk about the DTC and the DTCC. They don't talk about the MSCC, the NSCC, or the GSCC. These are important, Okay, because this is the process for which they're negotiating your securities, and they end up going over to Frankfurt, Germany, over and being converted into PIMCO bonds. And this is where we get them on the EDGE Act violation, because they're banking, and they're not supposed to be doing it in the several states or the Union of States. And thanks to Carl Killicott, I think I'm going to be able to substantially prove what I'm saying in their own literature, which is going to be a phenomenal thing. So the NSCC is the National Security Clearing Corporation. The GSCC, and this is the important one, Government Securities Clearing Corporation. So the GSCC is for the Government Securities Clearing Corporation. $1 trillion a day goes through the DTC, the Depository Trust Corporation. QSIP, which stands for Committee on Uniform Identification Process, is a trademark of Standard & Poor's, which is located on the bottom floor of the DTC, the Depository Trust Corporation, of 55 Water Street. QSIP, again, Committee on Uniform Identification Process, QSIP, has what is called SINS, C-I-N-S. C as in cat, I as in igloo, N as in Nancy, S as in Sam. SINS. QSIP has what is called SINS, which equals QSIP International Numbering System. Okay? So once they get the QSIP, after they're processing it, they get the SINS number, and this is for international negotiation, CINS, which stands for QSIP International Numbering System. For domestic, they have a 6-digit numbering system, and when they go international, which is where SINS, CINS, the QSIP International Numbering System, comes in, and ISID, that's I as in igloo, S as in Sam, I as in igloo, D as in dog, and that stands for International Century for Settlement of Investment Disputes, okay? ISID. Oh shit, did I get that one wrong? I got that one wrong. Motherfucker. Hold on. Comes in, ISID, excuse me, I misquoted it. ISID, I as in igloo, S as in Sam, I as in igloo, D as in dog, stands for International Securities Identification Division, okay? So from SINS, it goes into the International Securities Identification Division, which is ISID. It's called ISID Plus, PLUS, and they have a global networking system that includes Paine-Webber, which has 10,000 corporations in it. They are the major stockholder in CCA, which stands for and is Correction Corporations of America. Ladies and gentlemen, the politicians, the legislators, the lobbyists, they're all getting kickbacks for fucking putting us in prison for victimless fucking crimes, benign statute, code, city ordinance, rule, and regulation violations using maritime admiralty law, enticing us into a foreign jurisdiction using foreign would-be law to entice our vessels into a vessel in dry dock and fleece us and put us on the hook for it and whisk away the rents, profits, proceeds, futures, and annuities while our carcass sits in jail. The founding fathers would have cannons blaring right now. There wouldn't be a scallywag alive right now. They'd be going to town. CCA, which is Correction Corporations of America, and they are in Nashville, Tennessee. Everyone should have this list, and what they have done is privatized the private, for-profit prison system. Everything, even real estate, Jeannie Mae, Fannie Mae, all of HUD, all of it is international, ladies and gentlemen. This is all international banking. And this is why I'm so happy to come across Carl Collicott's work, because Through his knowledge and research, I have discovered they're not allowed to do banking internally. In fact, they are staunchly and heavily prohibited from doing so, and when caught, it comes at a very, very severe cost. And that's in fact what they're doing, trying to make it look like somehow you're a criminal, when in all actuality, they're just doing a simple everyday banking transaction, ladies and gentlemen. Literally what they're doing is a banking transaction. It's so simple, it's crazy. Everybody is feeding off the prison system, ladies and gentlemen. Everybody. Politicians, senators, congressmen, lobbyists, everybody is feeding off the prison system. Why do you think your schools are designed like prisons? That's so you become acclimated, because eventually, from cradle to grave, they expect you to be in one of their facilities, because that's how they fleece your estate. All right? They're going to hem you up for some victimless, benign statute, code, city ordinance, rule, regulation, which is really a banking transaction, hoping you don't catch on to what's going on, and you're going to volunteer to go sit in prison. You're going to make license plates for 6 cents a day or whatever it is, and they're going to make, hundreds of millions of dollars off you. All of the major corporations are feeding off the prison, the private, for-profit, industrial prison system. How many of you have heard of REIT, Real Estate Investment Trust? How many of you have heard of REIT? If you've got a mortgage, you've more than likely heard of REIT, Real Estate Investment Trust. How many of you have heard of PZN? PZN. PZN is the identifier for the prison trust. So the Real Estate Investment Trust, or PZN, which means prison trust. What about all the real estate? They own all the real estate because they hold all the bonds on them. You haven't redeemed your bond, so they didn't close your account. Remember when I was talking about running around waving your birth certificate around? I got one of these. You can't do shit to me. Waving it around is showing your whole ass, not just a plumber's crack. You're showing your whole ass, because you're showing them that you're still in constructive possession of it, engaged in usufruct. Therefore, you carry the liability for it. Damn is right. Damn is right. How do you put them back in their rightful position? Hand them back what belongs to them, right? Now all of a sudden they become fiduciary trustees again, because you're not running around with their asset, are you? You've forgiven them their debt, right? Now they're compelled to perform. That's 40 Statute at Large 411, Section 7E, 48 Statute at Large 112. That's Executive Order 100, Article 2, Article 31, Article 38. I could go on and on and on about it, but I just saw somebody the other day go, I used 40 Statute at Large, 40 Statute at Large 411, Section 7E, and they still took my truck. And just because I tell you about it doesn't mean that, Dirk, it's all set, so it's gold. You still have to enforce it, ladies and gentlemen. Did you read 40 Statute at Large 411, Section 7E, or did you just go in there and quote the statute? Did you just go in there and quote the statute at large and then not be able to tell them exactly what it says? It says full acquittance and discharge. It's in the first sentence. Anybody following any rule, order, regulation, or proclamation issued or made by the President of the United States or Commander-in-Chief is a full acquittance and discharge, and no one operating underneath any rule, regulation, order, or proclamation of the President can be brought into any court for any reason. It's a full acquittance and discharge. So when that guy put that comment in there, I was like, man, I really did do him a disservice. I did him a disservice. He thought he was just going to go in there and go 40 Statute at Large 411, Section 7E. That's it. That's it. And if you read further through that paragraph, at the end of the paragraph, it tells you that that birth certificate is actually a power of attorney making you the attorney in fact. But I could tell people there's no substitution for reading. I wonder how much I'm actually hindering people and causing harm to them, because they take what I say and they run with it, but they don't have a foundation, and they haven't taken the time to apply themselves and go read. There's no substitution for reading, guys. I was very I had a little bit of contempt for my mentors in the beginning because they would drop off books and I hated reading. They would send me digital books. Read this, read that, read this. And I mean, these weren't like 30, 40, 100-page books, okay? They're 900 pages, 700 pages of mundane, dry-ass shit. And I'm like, what you want me to do with that? Just read it, and then we'll have a conversation. You want me to read? This is going to take me 3 fucking years to read 700 pages, Bubba. I am not a reader. Back then, I wasn't a reader. Today, it probably doesn't sound like I'm a reader at all because I'm stumbling through the way that somebody else talks, and it's really hard because this is really just a transcript of what he was saying. And it's hard to speak like other people. But with that being said, I had some contempt for him. There's some disdain building up because I was like, why can't we just discuss this? Because there's no substitution for reading. You read it aloud, read it in your head, read it aloud again, read to comprehend, read to retain, top to bottom, left to right, Johnny. That's what they tell me. Top to bottom, left to right, Johnny. You know how we do it. Top to bottom, left to right. Read to retain. Don't read just to fucking read the words and skim through it. Read to retain so we can have an articulate conversation. And that's how I got where I am today. I slowed down. I tried to cheat. I'd read through it real quick and call them up, and they'd hang up the phone on me because I'd be asking stupid questions. They're like, look, if you actually read that to retain that, you wouldn't even ask that question because that's not even on the Richter scale. Bubba, you way off in left field. Click and hang up on me. So don't just take what I'm saying here and run with it. Go do some research, apply yourself, get a nice firm foundation underneath your ass, and then you can sound off like you got a pair. Because the bark will match the bite, and they will know by the veracity in your eyes that you ain't fucking around. All right? So anyway, when we come back, I just wanted to explain that part of the whole court system, banking system. I'm going to take a little break here. My voice is all fucked up. Take a little break here. I hope that was enlightening for you guys. I hope that appeases the ones that said, can you stop going live during crackhead hours and actually go live during a decent hour? I hope this was a decent enough hour for you. Put the crackhead hours on the way burner for now. When we come back later on, possibly today, I'm not going to guarantee it. Let's put it this way. If the good Lord have it so, I will see you guys later today, if the good Lord will it. Okay? And we'll come back on. We're on page 5. And we'll start talking about Lehman Brothers Bank, cartel, and we'll get into all that. Some of this stuff is not relevant for you guys to even know. He's, again, operating in the public using the UCC, and what Carl Collicott's pointing out is the UCC may be very, very, very detrimental to you because the banks can't do business with American citizens. So under the UCC, you're engaging in a commercial covered transaction and dealing with American citizen. It's a little bit different. His name is Carl Collicott. If you go onto Facebook, I've encouraged everybody to go check out his Facebook page. It's pretty amazing. I don't know that he's going to get back to you or anything, but I think his page is open to the public just like mine is, and be polite and respectful in there. You know, I already had some people get a hold of me and go, oh, he kicked me out of his Facebook. He blocked me. Well, don't be a dickhead. Don't go to somebody else's page and try to start a bunch of shit because you think you know something. All right, let me just put this into perspective, by the way. Let me just put this in perspective. Carl Collicott works with a former Supreme Court clerk and absolutely decimates fucking banks, by the way, on foreclosures, on repossessions, on alleged loans. And in fact, if you go and read his page, at one point he will tell you that the clerk of the court for the Supreme Court's like, we just can't fucking lose. I mean, our batting average is 1,000. We just can't miss. We could close our eyes and throw a lawn dart in the air and still fucking win. In fact, at one point on his wall, he expresses how the Supreme Court clerk, who's his friend, said that he watched an attorney go in and try and argue against Carl Collicott's work. And the judge said, if you ever bring that trash into my courtroom again, I will sanction your ass. Don't you ever come back into this court with junk like that again. That's how powerful his paperwork is. And he gives it away for free right on his Facebook. Or at least gives you enough that you could construct your own, which is pretty badass. All right. So his name is Carl. His last name is Collicot. And I have a shit ton of his work posted on my Facebook wall just as of recent over the last, 4 or 5 days. That's why I haven't been able to sleep. I've been reading all his work. And at first I started out trying to disprove it or discredit it. Couldn't do that because, and really I had a motive for disproving it and discrediting it because I have been using the FTC, the FDCPA, the CPB, I've been using all that. And then once he started in his post showing that that's still commercial, it ground my gears a little bit. And I was doing everything in my power to prove that he's made a bad assessment. And for 3 hours, I literally tried to disprove everything he was saying by going and looking up what he was saying and trying to find a chink in the armor, or maybe he just misunderstood and it's not being presented properly. And then after 3 hours of trying to thwart what he was saying, I finally had to fucking jump on board. And at that point, I just started reading all of his posts and going through it. And it's fucking brilliant. Last night, I went through his entire Facebook wall. I read every comment. I read every fucking post. I went all the way till, I think his Facebook wall allows you to go all the way, if you're not one of his friends, all the way somewhere into the beginning or the end of 2022, the beginning of 2023. And I read every motherfucking post. And they're long, but they are fucking good. And if you're dealing with banks and you want to be truly free, because remember, freedom's about liability, responsibility, and accountability. So if you really want to be free, financially independent, it's about liability, accountability, responsibility. Learning banking is a must. It's an absolute must. And so when we come back, we'll hit this next section here. It deals with mortgages and stuff, although the way that the CPA looks at it versus the way what Carl Collicot is showing are apples and oranges, guys. Apples and oranges. He's showing the congressional intent. He's showing the International Bank of Settlement saying that all these banks are foreign and they can't even do business with us by the International Bank of Settlement is saying that they can't do business with you guys or they can't settle the accounts with us. Okay? There's rules and procedures. And so they're all international banking. And the Congress is saying, well, if you're doing international banking, you can't have a deposit account for an American. You can't have statements and shit being issued to the Americans, inland, domestically. Only if they're external, outside of the United States, can you extend them a loan. Well, ain't none of us go outside of the fucking country to get a loan for a fucking car, did you? Nope. So guess what? You can destroy the ideology that there was a loan. Okay? So, I don't know. I'll read through this again. I'm not sure that I want to even share this part with you because this comes from Gene Keating, who is a brilliant CPA, had his master's degree, all that good stuff. But CPAs, again, look at it different than what Carl Collicot is showing us. And I'm telling you what Carl is showing has changed everything for me as far as banking and the public sector. Now, in the private sector, dealing with trust, there won't ever be anything that changes my mind on that. Handling trust, I'm going to tell you right now what Carl Collicot, C-O-L-L-I-C-O-T, Collicot is showing is the public, okay? But on the private, converting it into grantor beneficiary, them being the trustee relationship, you have the highest equitable claim. So either way you go, you can't lose, but you have far more to gain, in my knowledge and experience, in the world of expressing the trust. But as far as proving the bank can't lend money, the bank can't operate in the United States, the bank can't issue real estate loans to you, okay? That's so powerful, guys. So fucking powerful. So thanks again for all your prayers, love, wisdom, all the kind words, all the fuck yous, all that great shit. The good, the bad, the ugly. I like it all. I take it all. I enjoy the constructive criticism. Thanks for joining me. I look forward to seeing you guys, if the good Lord have it, later on today. Good Lord willing. And you guys all be blessed and have a great rest of your day. All right.